Yes, Mr. Beebe. Good morning.
Morning, my lords. My lords, I appear for appellant in this case, together with my wonderful Mrs. Julia Ormsby.
Mr. Beebe, the microphone in front of you doesn't amplify, it records, and so we'd ask you to keep your voice up quite considerably, please.
Okay, so I was saying I appear for appellant in this case. I'm instructed by Attorney Maître Jean-Marie Leclésio.
That's Ms. Arbisman, is that right?
Mrs. Julia Ormsby.
Good, thank you.
And my friend Gilbert Itier, SC, appears for respondent.
Yes. Proceed, please.
My lords, I'll try to be very brief regarding the facts of the case. In fact, since all these have already been presented to your lordships, I will, if I may be allowed, I will simply state this is a case of unjustified dismissal, unjustified because unlawful and unfair. Unlawful because the process involved in the present case that led to the dismissal of appellant was fraught with illegalities, one after the other. Not only several insignificant sections of the era were disregarded, but some of them actually trampled upon almost unscrupulously, without any scruples.
Trampled upon what, I'm sorry?
Trampled upon without any scruples by the respondent.
Thank you.
And unjustified because unfair. Because this case involved a situation where the respondent, claiming to be experiencing financial difficulties, had, according to the respondent, had to reduce its workforce, and in so doing, it disregarded principles of natural justice and principles established at common law in selecting the persons who were to be dismissed, one of them being the appellant. No reasonable, no objective criteria not only was not applied, but not even evoked, and invoked by respondent when selecting appellant for dismissal. Just a footnote on that. The only explanation for the selection of appellant was, strangely enough, he was one of the highest paid pilots of Air Mauritius. As if, again, this could possibly be considered to be a rational criteria when no information, no comparative information is given about any savings, about the incomes of the pilots, any savings that could possibly be made or had been made by selecting appellant on the sole criteria that it was allegedly one of the highest paid pilots, but I said without any. So this is what this case is about.
Well, now, Mr. Beebe, you have been articulating a discrimination point.
Yes.
You say it's what the case is about, but discrimination is not something that was articulated in the lower courts, and indeed scarcely finds articulation in your written case. Are you not in difficulties in elaborating upon this point here this morning?
Respectfully, my lords, before mentioning how I mentioned that issue myself, may I respectfully refer your lords to the submissions of my learned friend before the Supreme Court, where there is a heading in bold called discrimination in the submissions of my friend at page 2.
Well, his case begins at 326, I think I'm right in saying, Mr. Beattie.
Page 2002, my lords.
2002. I didn't know our papers went up to 2002.
So 202.
202. Very well.
Sorry.
Yes, we've got that page.
At the very top, with the heading underlined in bold, my lords.
But this is his skeleton argument
Yes.
before the Supreme Court. We are addressing what is on the agenda for us, and that is the agenda set by your amended grounds of appeal, subject, of course, to the withdrawal of certain of those grounds that you helpfully explain in your case.
But my friend here, at page 202, was in fact responding to what was argued orally, but I'll give your lordship the reference, as regards the selection of the appellant, not on the ground that it was the highest paid employed on fixed term contract, because discrimination has many forms, my lord. You mentioned the discrimination on the basis of selection by the fact that it was in the category of fixed employment, of being as in contrast to those who were on contracts of indeterminate duration. However, what was the facet of discrimination that was actually canvassed in the court below was the fact that it was of national and non-national.
Quite. The expatriate point.
The expatriate.
Yes, very well.
That's very
It may not help, Mr. Beebe, and if it doesn't, please say so. But I'm just looking at section 46 of the Act, because am I right in thinking that it's section 46 which creates the right, in some inappropriate cases, to severance allowance? Is that right? Okay. Well, now, which of the sections do you say you fall under?
(46.1), my lords, deals with the situation where the employment is terminated by the employer.
Yes? Got that. And where there's been continuous employment. And if you have those two conditions, then, wait a minute, then severance pay is payable if you're within subsection 5.
Yes.
Is that right?
Yes.
Okay, now which one of subsections 5 are you in?
D, my lord.
Right. very much. Any of the others? Any of the others?
No, my lord.
I hope I'm not asking you to think about something completely new.
No.
We're quite late on in this litigation. All right. Well, thank you very much. That's very helpful.
Well, Mr. Beebe, you've heard what I've said about discrimination, and you've heard what my Lord, Lord Hughes, has pointed to as being the matters that you need to establish to get within Section 46. So proceed, but proceed in the light of those two indications, which I hope are helpful to you.
Thank you. They are...
Very well.
I was saying, my lords, that the contract were involved in this case has to be interpreted within the framework of the Employment Rights Act. My lord has referred to sections 46, but obviously the other sections that we must bear in mind when interpreting this contract would be first, section 2.
Yes.
Section 3.
Section 2, you want the definition of continuous employment.
Yeah.
We understand that already, obviously.
Yeah.
Thank you.
Section 3, section 36(1) must be discussed because the Supreme Court judgment is based on an application which respectfully I consider wrongly applied to the present case of section 36(1). And, of course, with the permission of your lordships, the question of section 37(1). And my learned friend...
Now, section 37(1), you say with the permission of the board. You rightly say that because you indicated in your case that you proposed to ask for permission to take new points, of which, correct me if I'm wrong, the third was section 37(1).
Yes.
Now, you've seen Mr. Itier's response to your application for permission. We know that you have been wrestling with this case intellectually for 10 years. You said that in your case, very frankly. And here you are, the month before the final disposal, raising 3 points. 3 points which have not been considered by the local courts. And you know, as well as we do, that the practice of the board is in those circumstances not to entertain them. How can you jump over that high hurdle by persuading us to grant permission this morning, Mr. Beebe?
First of all, respectfully, my lords, if I may refer to the objection raised by my learned friend.
Certainly.
He quoted the case of Grevels, the Mauritian case decided by this board. Now, let me just mention that quite rightly, and I do accept and concede that that my intellectual wrangling has gone more further than it should, probably in this case. But, my lord, the case of Grevels indicates that, as you've rightly said, this board normally would not entertain points not taken, but Grevels also explained in Grewal it is explained that
You want to go to it, do you? Oh, very well. Well, then let's do that. I think we find that at page 830, or the relevant bit of it.
in the case of Grewal, the board observed that the point that it was proposed to take was raise complex issue of interpretation of employment law, and that it will, if I may quote, it will be unfair to the other party to this case and potentially dangerous the development of British employment law for the board to rule on its own without the necessary groundwork having even been interpreted. Now, whereas in several other cases, i.e., the present point, section 37.1, my lord, is a pure point of law. Indeed, it's a point that, in my humble view, involves a matter of public order. Because this point on this section rests the whole edifice that the era puts forward for the protection of employment. It is not a point that is fact sensitive. There is no dispute at all. And notice was given a full, unlike the case of Grewal's, that was turned up very late, a matter, I believe, of 24 hours when the matter was presented. In this case, I raised this matter 3 weeks fully in advance. And in fact, my learned friend, though he said succinctly, did reply to it. In his statement of case, my learned friend responded, quoting Grewal's. So, if I may refer the board to the case of Connecticut.
Reference, please, Mr. Beebe.
Sorry?
Reference, please, Mr. Beebe.
Connecticut Fire Insurance versus Kavanagh.
Page reference, number.
8995.
Thank you. Yes, which bit of it?
An 1892 case, my lord, from the Quebec, from the Queen's Bench for Lower Canada, province of Quebec.
What's the passage on which you rely, Mr. Beebe, please?
When a question of law is raised for the first time in a court...
Page? Sorry, Mr. Beebe, what page are we on?
Page 1000, my lords.
Thank you very much. Yes.
Second paragraph, my lords, of page 1000.
Yes, we've got that. Thank you.
And if I may, my lords, when a question of law is raised for the first time in a court of last resort, upon the construction of a document or upon facts, either admitted or proved beyond controversy, it is not only competent but expedient in the interest of justice to entertain the plea. The expediency of adopting that course may be doubted when the plea cannot be disposed of without deciding nice questions of fact in considering
Well, we've read on, and we see what the board said as between questions of law and questions of fact in 1892. Just very briefly, before we rule on your application for permission, let's just go to section 37.1, if that's convenient to you.
Yes, my lord.
We've got it in its original form at 872. A party to an agreement, other than an agreement for a specified piece of work or for a period of time, may. Pause there. These agreements were for periods of time, weren't they?
Yes.
These were determinate contracts, weren't they?
It's a fixed duration.
You've said that, and let's proceed on the basis you're right. Section 37.1 excludes those contracts from the provision that it makes.
Yes, my lord.
How then can you say that section 37.1 is relevant to this case?
In the present case, my lord, the respondent relies on such a clause that section 37 seeks to outlaw, to prohibit, to effect.
Well, that's notice to the minister, isn't it?
So yes,
37.6 is notice to the minister.
37.1 is notice to the minister. That's what I said is the whole basis of the foundation of the legal framework to protect employment. It is informing the minister by giving him prior notice.
Now, Mr. Beebe, you've come a long way. You've put a lot of work into this case for your client down the years. And we want to be very fair about how we dispose of these points. But before we decide on your application for permission to re-amend, I think it is, because we've already got an amended grounds here, I just want to be clear that your other 2 points that you want to take fresh are, first of all, the date point, the move to the 3rd September. Isn't that your point number 1?
Yes,
the move to the 3rd September from the date at the end of August. And the second point you want to take is notice to the minister not given in time. That's 1 and 2. And then 3 is section 37.1. Am I right about that?
Yes. Yes. There's a point regarding contracts of fixed duration. That's 37.6, I believe.
Section 37.6 is notice to the minister.
Yes.
That's your second point.
Yes, 37.1 is the question that outlaws clauses like 10A. That's an issue in this case, my lord.
Anything more you want to say on your application to re-amend to take 3 new points?
Well, all these 3 points, my lord, as I said, all of them are not points that this board would require to have the benefit of it being canvassed or educated upon by the lower courts. They are all pure points, straightforward point of law.
It doesn't follow we wouldn't like to know what the Mauritian courts think about it.
Well, if I may, my lord, refer to the point as giving notice to the minister. Either notice was given as a matter of fact, or it was not given. If it was given, then there's no problem if it was not given, but believed it was, for example, in the lower court, the magistrate assumed in a judgment that notice was, she actually refers to it in a judgment at page, page 98, my lords.
Which line?
103, sorry, my lord.
102?
103.
103, very well. Which line?
The second paragraph, the
Very well.
fifth line.
What's this?
Company took the decision after notifying the minister.
As is stupid.
You say the decision was taken at the same time as notifying the minister or before the minister was notified.
Took the decision. For the magistrate, she was under the impression, obviously a false one, that the respondent had given prior notice. First there was a notice, and then there was a dismissal.
So, Mr. Beebe, reading this and thinking what your grounds of appeal to the Supreme Court would be, why didn't you take this point then?
To be quite frank, my lords,
Yes,
at
do.
the Supreme Court, we were focusing on two main issues that were baffling us in this case. The confusion over the notion of continuous employment, what that seems to bedevil this case. It was rejected by the court below without giving, quite frankly, any reasons for it. And at the Court of Appeal, we again struggle over this statutory construction of continuous employment. And we were also attempting to show that the provision in the contract clause 210A was not legal, and it is mentioned actually, this is actually not quite a new point. It is argued in my submissions in writing that clause 10A is not legally tenable because it does not provide at all, the wording of the clause does not exclude the payment of severance allowance.
Well, we may go into that in due course.
Yeah.
Unless there's anything more that you want to say about your application to re-amend, I think the board will retire for 2 or 3 minutes
Yes.
to decide where to go from here.
Thank you, my lord.
Thank you, Mr. Beebe. As foreshadowed in his written case, signed, I think, in March 2018, Mr. Beebe seeks not only to withdraw certain points previously made, of course he can do that, but to re-amend the grounds to take 3 new points. The litigation has been proceeding for a very long time, and these points are taken but 1 month prior to the board's examination of the case. It is most unusual for the board to consider a point not taken in the courts below, because the foundation of the board's examination of a case is the disposal made in the courts below and arguments constructed thereon. If a new point is so central to the board's examination of a case, to a case that, if ignored, it would mean that the disposal of the board would really go off on an entirely false basis, that would be one thing. But Mr. Beebe's points are not of that order. With his considerable help this morning, we have looked briefly at all three of them. The date point, the minister point, and the section 37(1) point. And we have to say provisionally, we think there's no merit in any of them. But we're not going to consider them and reach a concluded view because they simply come too late. And we hereby refuse permission to Mr. Beebe to re-amend to take these points. Very well, Mr. Beebe. Well, then the appeal will now proceed on the points that have been regularly raised by you. So you're going to be dealing with continuous employment. You're going to be dealing with the significance or otherwise of unilateral termination. And you're going to be dealing with, as Lord Hughes has reminded you, what you need to establish in order to secure a severance allowance. So we look forward to hearing from you now on those points, please.
I will proceed in the order that you have
That would be very convenient.
outlined. On the issue of continuous employment, my lords, I will be very brief. It is a statutory construction, as explained in my statement of case, that Parliament wanted to prevent the abuse and manipulation of a number of successive contracts of fixed duration. It goes very way back, not only in the history of Mauritius, but in the, as I mentioned of case, various jurisdictions have been very wary, have been very vigilant about this the risk posed to the employee of successive contracts of fixed duration. And the Section 2 provides that contracts that are not separated by gaps of 28 days should be deemed to be continuous employment, i.e. the employment relationship goes beyond, is not merely a matter of the end of a contract, but the relationship as a whole, taking into account the amount of years for which the employee has worked for the same employer, whether or not on the same terms and conditions, even if the terms and conditions of the various contracts vary. On the facts of this case, there's no dispute that there were no gaps of 28 days. My learned friend disagreed, and the code below, the industrial code, took the view that appellant was trying to convert his contracts of fixed duration into one of indeterminate duration. That was never the argument of appellant. The appellant is relying clearly and simply on a true construction of Section 2 of the Employment Rights Act. My learned friend actually submitted in the code below that Section 2 should apply to contracts of indefinite duration. If I may respectfully say, that would not be possible. That would be possible because an employee employed under a contract of indefinite duration, if he has been employed for more than 12 months, is de facto in continuous employment once he has worked after 12 months. So it is clear that Section 2 was not meant at all for contracts of indefinite duration. And my learned friend referred to a worker being absent, for a long time, then he is for, having in mind Section 9 of the era that talks about continuous employment in situations where somebody has been detained by the police for 60 days, when an employee has been pregnant and absent, etc. But that has nothing to do with Section 2. Section 2 is about that the law will deem an employment relationship to be continuous once there are no gaps of 28 days between the successive contracts. As simple as that. So as I've said, there should be no difficulty, in my humble opinion.
Well, you've made that submission very clear.
Yeah.
And if necessary, we will hear Mr. Itier on it. So would you, well, no, but you now proceed. I think we would like you to proceed on the other limbs of your argument.
Yeah. Now.
And so you're going to address us about whether there has been, in this case, a unilateral or a consensual termination.
Exactly. Now,
what do you say about that?
in my view, and in the view, and on this matter I agree respectfully with the learned magistrate of the industrial court, the contract was unilaterally, and if I may quote her, prematurely terminated by the employer.
That's certainly what the letter said.
Yes, but surprisingly, and I must say, and rather was quite baffled, the Supreme Court disagreed. The learned judges took an opposite view. And even though my learned friend tried in his statement of case to say, no, there is no contradiction between the view of the learned judges and the view of the magistrate, the letters, the facts speak for themselves. Indeed.
I think it would help us to go to what the Supreme Court said, and then you can make your submissions as to why, in your submission, what they said was in error. It's really, is it at the top of page 228, Mr. Beebe?
I think so, yes, Madam.
Third line, there has been no unilateral termination of the contract by the employer which would entitle the appellant to any claim for severance allowance. Now, how did they reach, in your submission, how did they reach that conclusion, Mr. Beebe?
They reached that conclusion, my Lord, in my view, because they relied on the case of Mauritius steam navigation, at least on one of the principles, in my view, a truncated one, of Mauritius steam navigation that is mentioned at page 226.
Yes. And they quote the court as saying it's evident that it was an ordinance in those days.
Yes.
Doesn't find its application in the case of a contract of determinate duration, which comes to an end by the happening of the event predetermined and agreed upon by the parties. Such end does not come through the agency of the employer, but by the common will of the parties.
Exactly, my Lord.
I was wondering whether you were going to submit to us that they should have read on a bit in the Mauritius case. And I was wondering whether, if it was convenient to you, we might go to page 551 in our bundle. Is this the Mauritius case?
Yes, my Lord.
Have you got 15 lines up from the bottom, the bit that the Supreme Court quotes, beginning, "It is thus quite evident"?
Yes, my Lord.
So they quote that bit and the second sentence, "Such end does not come through the agency of the employer, but by the common will of the parties." And there the Supreme Court ended the quote. I wondered if you would be submitting to us that they might have read on a bit
Exactly.
and said, quoting, "But what if a fixed-term contract is terminated by the employer before the predetermined date or event?" Is that your point?
Precisely. And in fact, I quote, there are further quotes in my statement of case, my Lord, where I step by step, I go further, because the judges in that course go further and conclude, as they do, that even in cases of fixed duration, if it is done at the instigation of the employer, severance allowance would be payable, provided, of course, other conditions like continuous employment, and the dismissal, the termination is not justified.
We thought you might submit that, and we'll have to decide whether it's valid. But there we've read the court asking a question, but what if a fixed-term contract is terminated by the employer before the predetermined date or event? And then I think, Mr. Beebe, in your case, you helpfully quoted a later passage where the court gives an answer to that question. So if we turn over to 553, right at the bottom, I think this is a bit that you quoted in your case. Our conclusion, therefore, is that the jurisdiction of the magistrate under the ordinance is exercisable only in the case of termination of contracts of employment of indefinite duration and of contracts of definite duration which have been terminated by the employer before the prescribed date or event. Is that the point you're making?
Yes, my lord. There is something that is not clear, if I may, my lord.
Certainly.
When we refer to the quote of the judges in their judgment about common will of the parties, there is nothing on the facts of this case, unlike in the case of Mauritius Steam Navigation, of any agreement about a predetermined event. There's no predetermined event at all involved in our case, my lords. What is there in that clause is an agreement on a mechanism to give notice. That's all.
Yes, the argument is it, that the contract, which is, of course, consensual, allows for unilateral termination on either side.
Yes, my lord.
But it still remains unilateral.
Yes.
Got it.
But that is why, my lord, respectfully, I stated in the beginning that the contract has to be interpreted in the framework provided by ERA and the various sections I listed, and of course by the French authorities of Lamy, which I mentioned, that that does not allow an employee to contract out of the statutory provision, the statutory framework. That is why, in my view, the learned judges went overboard when they interpreted what they call under Section 36(1) as a measure of contractual freedom. They believe that this contractual freedom went so far as to oust, or as to do away with the impact and the bearing of legislation pertinent to employment protection, as if that could be contracted out. I don't want in a kind of back door come back to the ruling of my lord, but that is why the ERA, as a matter of law, provides for this overall. There's an architecture. One links to the other, from informing the minister to going the permanent secretary investigating, to providing information to the minister, etc., so that this matter can be looked at, and if necessary, the Ministry of Labour in the Act itself takes it upon itself to bring the matters to court when there is a violation of the provisions of this part of ERA.
Mr. Beebe,
yes, please.
Was Mauritius Steam Navigation Company a case where notice was given pursuant to a contractual provision which entitled one of the parties to terminate?
on the facts of
Yes.
the migration, as far as I know, there was an agreement that the contract would end on the last voyage.
Yes.
There was no termination clause, just like in Sadia. There was no termination clause in these cases.
So when the Supreme Court refers in the passage on which you rely and to which my Lord has referred at the bottom of page 553 to a contract which has been terminated by the employer before the prescribed date or event, it would seem that the Supreme Court is not referring there to termination pursuant to a contractual provision for termination.
Yes, my Lord.
Yeah. Thank you.
Certainly.
Well, then, in the light of that, Mr. Beebe, let's take Lord Hughes's suggestion and concentrate on section 46,
Yes, my Lord.
if you've got it to hand. Where a worker has been in continuous employment, you say that Mr. de la Haye was, and the employer terminates his agreement. You say the employer did terminate his agreement. The employer shall pay severance allowance to the worker as specified in 5. And we go down to subsection 5, and we see that the court may, where it finds that, and you accepted that D is the relevant subparagraph, the grounds for the termination of agreement of a worker for economic, technological, structural, and then I wondered whether the word reasons was missed out there, but it doesn't matter, or similar nature affecting the enterprise, do not constitute valid reasons, order that the worker be paid severance allowance. And so if the court finds that the grounds aren't valid grounds, you can get your severance allowance. Now, the grounds put forward were economic grounds. The magistrate upheld them as being valid. The Supreme Court didn't reach that point, and you have, perhaps realistically, abandoned your complaint to the board that the economic reasons were not valid reasons. In those circumstances, having perhaps jumped hurdles 1 and 2, how can you jump hurdle 3?
My Lord, respectfully, on the issue of the abandonment of the grounds of the validity of the economic grounds, may I most respectfully refer your lordships to paragraph of my statement of case.
Yes, of course. 311. Yes.
And bearing in mind the contents of paragraph 9, just prior to paragraph 10, and bearing in mind, my lords, the way the case had been dealt with before the industrial court and the Supreme Court subsequently. The industrial court examined both the validity, whether there has been compliance with clause 10A by the employer, and found that there has been, the magistrate, and then she proceeded to adjudicate upon the economic grounds. Whereas the Supreme Court agreed with the magistrate that there had been compliance with clause 10A, and said there was therefore no need to examine the economic grounds. Now, the difficulty, if I may take the last position first, once the learned judges limit themselves to examine clause 10A, I said the contract provided for this, for giving notice, this was done, and that's the end of the matter. But there we go to a very dangerous position that there can be termination of a contract of employment without reason, without cause. This is, in my humble view, respectful view, what the learned judges' effect of their judgment is. We go back to a situation which was denounced actually in Mauritius 16. It abrogated the previous ordinances, in fact the Labour Act and ERA says you must have a reason when you dismiss an employer. An employer, unless in certain cases of course in contracts of fixed duration, the contract comes to an end at the end of the period agreed upon. That's no problem. You can also have an employee resigning, etc. But the right of an employer to dismiss without reason has long been done away with, not only in most jurisdictions. And the learned judges, by stopping there and saying, well, there was this notice, it was given, never mind why, I think that is in gross contradiction and totally going, if I may say, backward in history, as actually pointed out.
So you read the Supreme Court judgment and you said to yourself, that's wrong. But what perhaps you didn't do was to do what Lord Hughes advised us all to do, which is to look at Section 46. You can only succeed if you comply with all the requirements of the section.
Yes, well, yes.
And we are asking you how you can comply with the third hurdle that you face in circumstances where the court has got to find that the economic reasons given are not valid reasons.
That's why I was in paragraph 10 of my statement of case, given the background of the dangers of advocating on both the contract and the economic grounds, I nevertheless, in the last line of page 312, I say, appellant will not therefore insist on offering full-fledged submissions in respect of the economic grounds as they are not considered to be the cause, as a cause, but only as a context in which respondent sought to invoke clause 10A. Because the letter of dismissal clearly says that appellant is being dismissed, quote, by virtue of clause 10A, triggered, of course, by the alleged economic difficulties. And I want them to say it was an error to treat the context as a cause, because the learned magistrate could have found herself in an impossible situation had she found that the economic grounds to be invalid. And that would have meant, because she had found there was unilateral and premature termination, therefore at the instigation of the employer, she would have found compliance with clause 10A, which would have rendered which according to her rendered the termination lawful, and she would have found the termination unlawful because she could have found that the economic grounds were not valid. So that would have been, in my view, a judicial catastrophe, which was avoided by the judges by not touching at all the issue of economic grounds and by limiting themselves to saying that, well, there has been compliance with that clause. Now, my Lord, I'll go on to say at this paragraph, I would like, however, with your permission, to offer some observations, or should the board deem it necessary, submissions will be offered on the subject in the conclusion to appellant case. Therefore, my lord, it is not quite, if I may respectfully point out, not quite the case that I have abandoned. And indeed, if you go to the ground of appeal, which is maintained at 4A.
Where do we find that, please?
Ground of appeal, my lord.
(301).
3.
You mean the amended grounds of appeal,
Yes,
don't you?
at page 301,
Exactly.
4B.
Right. Thank you.
4B, my lord, I will read the whole, but the second part is what I have in mind. The learned judges fail to appreciate that clause 10A was never intended to have any incidence or impact on the liability of respondent to precedence allowance. Now, further, it did not and could not negate nor obliterate the reality that appellant was in continuous employment. And then I went on to say, my lord, consequently, the dismissal of the appellant at the instigation of respondent would entitle the former to be paid severance allowance if it were to be proved that the latter had put an end without justification to the employment relationship. So, put an end without justification is in fact invoking economic grounds that are not valid. And when you take the amendment of appeal 4B together with what I have just pointed out, my lord, you will, that's why I reserved, of course, with subject to the permit of the board, not first to offer observations, and it seems to me that it is now necessary for me to, if I may have a attempt to go over the hurdle, my lord, it be necessary for me to demonstrate that the economic grounds put forward by the, in fact, my lord, that should, if I hope not too presumptuously, that hurdle should not be that high to overcome, to jump over.
When we read your statement of case yesterday or a few days ago in preparation for this important hearing, we read, of course, your introduction, which, very politely crafted by you, says at the very beginning, I beg leave to inform you, the appellant hereby requests permission to withdraw its grounds of appeal 1A, 2, 5, and 10. So, of course, with my pen, I went back to 300, 301, I expect we all did the same thing, and I crossed out, in particular, ground 2, which was the economic ground. And perhaps more relevantly than what we did with our pens is what Mr. Itier would have done with his. He reads on the 15th of March that you're abandoning fully fledged submissions on economic grounds, and he comes over to England on the basis that economic grounds will not need to be justified anymore. So this is an unfortunate situation, Mr. Beebe, to put it mildly. And all you're not asking for fully fledged submissions, but in the circumstances, we will allow you a few minutes to address us on the economic grounds and on how you could begin to displace the conclusion of the industrial court by reference to that mountain of evidence that in 2008 and 2009, of all years, the airline was doing so badly, that the economic grounds were not valid grounds. So yes, notwithstanding your concessions and your withdrawals and the confusion, you have a few minutes in which to address us on the economic aspect.
My lords, there is on record evidence regarding, not controversial evidence really, regarding the losses being suffered by the company. But I would point out that it is common ground between the witness for appellant and the witness for respondent that the losses were caused not by the operations of the various routes, but by the edging difficulties,
yes,
the edging dimension. And that without the edging, the airlines were profitable. Now, the economic grounds, my lord, has two limbs. One, it is not enough for the employer to say, I have difficulties. He has to convince the court that it was reasonable to select. This is what I mentioned in my introductory part of my submissions, to explain why, in particular, appellant had to be dismissed. And in my view, my lords, there is a comprehensive, authoritative rendering of the principles involved when an employer goes through the exercise, and that is to be found in Mauritian law in the case of la bonne chute, which is la bonne chute, which is to be found, my lord,
Yes, which page, please?
actually I quote from it extensively in my statement of case, actually.
Do we have the report?
In my statement of case, I quote as 316, but in the bundle, the relevant
That
point-
indicates we've got it at 832.
At page 83, too, there was a quote from it at page 83,
Yes,
my lord,
thank
the
you.
extensive quotes, which I will refer to.
832, did you say?
No, yeah, but
Yes? What do you want us to read from this one, please, Mr. Beebe?
given the time I have, I will not go into the history and the purpose of the exercise of selection, which used to be done by the TCSB, and now we devolve on the Learned Magistrate of the Industrial Code to carry out and to have step in the TCSB. But in that case, my lord of La Bonne Chute, it was established. The board took the view that even where an employer can establish that it has good reasons to dispense with the services of one worker or more than one for that matter, it must also, before the board can find that a reduction is justified, show that the decision to dismiss a particular worker is a correct one.
That was the decision that the board had made.
This is
the court, isn't it?
or is this, was it then a board?
No, this is an action brought against the board, isn't it?
Yes.
Was it an action challenging the decision.
No. It is a case of workers, the board. This is the TCS, the defunct TCSB, which was abolished under the 2008 Act, but revived. Sorry.
I know, but look, in the middle of page 832, the applicant, a short paragraph, has obtained leave to ask this court to bring up the board's record for the purpose of quashing it, on the grounds that it's an excess of jurisdiction. Now, in dealing with that application, does the court give its opinion on the point that you've just mentioned? Good.
The
Where?
Supreme Court vindicated the stand of the board.
Well, where do we find that?
Yeah. So the Supreme Court, therefore, is stating.
Where do you want us to read from?
In my page, the board took the view.
Which page and which line, roughly?
In the bundle, it's page 832, but I will refer.
Maybe it's 834, the second paragraph, Mr. Beebe.
Yeah.
Yes, my lord, it's 834.
Thank you.
The second paragraph.
Mr. Beebe, wasn't there evidence before the industrial court that the expatriate pilots were paid more than the local pilots?
Yes, my lord.
Was that not given as a reason for the termination of their contracts?
Yes, in the sense, my lord, to be fair to the position of the company, they didn't explain. They didn't go that far. I found that actually strange. It said the pilots were paid more, but as I said, they were paid more, and mention was also made of various advantages. They had housing allowance, etc., etc. But my lord, this is mathematically does not mean anything if the accountant do not provide a comparative analysis of what the other pilots are costing in terms of pension, in terms of medical, or whatever, without comparing it to the terms and conditions, and not only of other pilots, my lord. An airline is just not made up of pilots. Such a major...
If there's a cash flow problem, though, you're not going to be worried about future pension liabilities. What you'll be concerned about is the current expenditure involved in employing the expatriate pilot on the one hand as compared with a local pilot on the other.
Yes, but this was not made. Under evidence on record, there is nothing that allowed neither the magistrate nor the Supreme Court is going to it, nor this board to find out what is a cash flow problem, and now dismissing the expatriates help with the cash flow problem. There's not one iota of evidence on that. It was sufficient to say they cost more, they are foreigners, they cost more, but that's far from being enough. It indicates something. It indicates they get more, but more in comparison to what? We do not know. They didn't bother to say at all. And amazingly enough, when the accountant for the respondent gave evidence in court, he didn't spend 1 second, not one word about the cost of the foreign pilots. Not one single word he talked about. He tried to talk about edging. I tried to cross-examine, you will see on record, and I was told it was political matter. I cannot talk about edging. That's on record, my lord. When the letter of dismissal mentions edging in the very first sentence of the reason why closed tenure was triggered, any attempt to discuss edging, niet, in court, on record, my lord, is political, if I'm quoting. So, we could not, and amazingly, when the accountant was asked about edging for the respondent, he told the court, I'd rather not go into that. That's the answer of witness for respondent. It declined to explain. And my lord, this is a reason given over and over again in the letter of dismissal why the company was in difficulties. Taboo to talk about it. Their witness refused to talk about it. On recall, my lord, if I don't have time, I could quote you the relevant passages. No, he would not talk, even when examined by counsel for it, but he would not talk about it. He said, I'd rather not go into it. So, in this situation, it's not easy, my lord. But in any case, there's something more about La Bonne that is important, my lord. La Bonne said, and I would like to emphasize that, there must be reasonable criteria, objective criteria. In my statement of case, my lord, I refer to a number of cases, some from the United Kingdom Employment Tribunal, where there must be objective criteria. There must be, La Bonne says you have to be reasonable when choosing. In the British era, the standards are set out. I do not wish to just take on the whole, transplant the British era, where it laid down the standards. Discrimination between same category of employer. After 3 years, you qualify into permanent, etc. I don't want to go into that. But the fact remains, La Bonne states that you must be reasonable. And when Section 46 talks about the grounds being valid, the grounds being valid, my lord, include that not only substantially but procedurally, things are done fairly. That's why initially at the beginning, I argued that this is a case of unjustified dismissal because unlawful, well, again, I don't want to go back now, structural provisions of the era were not observed, as I've mentioned in our view, and the requirement that the employer must act fairly were not involved at all. It is not sufficient for an accountant to say, well, there were losses, and for the learned magistrate, my lord, she limited herself to say the following.
Yes, let's see what the industrial court said about this. So we've got this at 98, is it?
Yeah.
It's really the final page, isn't it? 103.
At some point, my lord, she refers to the the published statements of the company.
It's 103 at line 12 to 13. 10, somewhere around there.
My lord, at that page 103, the second sentence says, a scheme had to be devised to cut down costs, including manpower, in order to cope with the problem. That's exactly what I'm about, my lord. If you follow the reasoning of La Bonne Chute, there must be a scheme. In the present case, there was no evidence at all given about the scheme, either by the witness from human resources No, by the accountant. Not one word about any scheme. At all. Zero. Indeed, that scheme should have been scrutinized by the magistrate of the industrial court as it used to be scrutinized by the termination of contracts of service board. In those days, when I appeared before that board, there were economists, evidence was adduced about what the redundancy is about, the losses, what can be done. Not an accountant that refuses to talk about the very cause of the problem, so I won't talk about it. The magistrate said a scheme had to be devised. There's no scheme, my lords. The only thing that there is, a decision to what I call to get rid of the expatriate pilots. My lords, there's worse on this score. First of all, new pilots were employed. New pilots were employed a matter of months. Most amazingly, it was submitted by a respondent. Well, this was a usual thing that happened around this time of the year. We employ new pilots by around that time, and we did it, so what? This is to be found, my lord, in the submission of respondent. We are supposedly, the respondent is supposedly going through very hard times. And you have the explanation, my lord, that new pilots were recruited because this is a thing we do at this time of the year. So it was an exceptional circumstance then. It's most disturbing. But there's something equally most disturbing, my lords. Very shocking indeed. And that is to be found. Let me, if I may, just give you a flavor of the evidence from Mr. Mering, who was president of the Pilot Association, at page 49.
You are,
at page 49,
preying on our good nature.
Yes,
because this ground has been effectively abandoned. But we have given you a few minutes. And we will go to this page. Which is it?
Page 49, my lord.
Very well. Yes.
Page 49, you see that new pilots are being recruited. They were given, do you know for how long these pilots were employed? In the fourth line, my lord.
Yes.
They were employed from November up to the 29th. They were given training, and then we'll see evidence a few lines below. A recruitment drive is in process.
Whose evidence is this, please?
Sorry?
Whose evidence is this?
The evidence of the president of the Pilot Association.
It's another pilot called for the claimant, is that
Yes.
right? Got it. Thank you very much.
And my lord, his evidence, his testimony was not challenged at all.
Yes, I follow.
Mr. Beebe, can I just ask you to go back to the question of the plan? You said there wasn't a word about a plan.
Yeah.
I wonder if you would turn up page 69 of the file we're in at the moment, please.
Yes.
And I think this is the evidence we see on page 58
Yes.
of Mr. Sukun, the Senior Manager, Financial Accounting of Valley de Plat, etc.
No.
And if you look on the middle of this page, you are asking about a plan.
Yes.
And he says, I don't have a copy of it now, but
Yeah.
we can produce the plan,
Yeah.
we have it,
Yeah.
and that is agreed on.
Yes, my lord.
Did it happen?
No,
Right.
not at all.
But there was a word here about
He mentioned the plan exists, but he didn't bring it to court. And therefore the court could not examine it.
Okay.
So the court concluded the grounds were valid without the respondent bothering to subject the plan for the examination of the court. it remained with the respondent. It was never submitted to the board for scrutiny or examination, and certainly not for education upon. So, if I may sum up now, I don't want to take advantage of your indulgence, my lords. If I may, my lords, say, as I said in this case, you can see it's a bit strained the way it has been dealt with from the very beginning. The two horses metaphor I use, clause 10A, economic grounds, and off when the process is abandoned. But at the end of the day, what do we have? We have a clause in the contract invoked to terminate the contract of fixed duration, a clause that does not exclude severance allowance, a contract that makes no reference to any force majeure at all. No provision is made for external circumstances impinging or impacting upon the contract that may make the contract impractical for performance. Nothing at all is contained in the provision of the contract. There is no foreseeability. Whilst we also have in this case, and that is relevant, the training bond, in which there's a commitment, which, by the way, was implemented because the 205 contract was stopped and the 2006 contract. A new contract was signed midway after the appellant had received training to fly Airbuses. We used to fly 7. All this is done. More than $1 million rupees is spent to train him. And in that training bond, there is mentioned that there will be, if his conduct, capacity, performance, and suitability, if his conduct is okay. So this was a performance-based contract. And therefore, when you have come to make redundancies, why not assess, compare his performance as a senior pilot to other pilots? That would have been more reasonable test criteria. Because all along, you have said if you're capable and if you're suitable for the job. If this is okay, you will be employed anew. Now I must say something which has to be corrected, my lord. It is not. It is a fact that there's been both in writing, as I said, training bond. There is mention of renewal, because my learned friend contends when I put forward the case, a Canadian case of Senol, which it's a Canadian Ontario case of Senol, in which a lady was employed for some 16 years she's in the bundle, my lord.
It's a Canadian case.
Canadian case of Senol. My learned friend said in Senol there was talk, it's about continuous employment also, there was talk of renewal. That's why the judges found in favor of, I don't agree. In Senol, the ratio de change was the fact that just like under Section 2, this employment was meant for the job itself requires a contract of indeterminate duration. So my point here, my lord, is that the intention of the two parties in this case is clear. The intention, there is enough evidence to say the intention was to maintain the continuity of the employment. There's so many indications of that, including, my lord, the fact that is not challenged in cross-examination, that what used to happen, at the end of 4 years, the appellant would be told by the chief pilot, A1 Mr. Roddy, send a letter and your contract will be renewed. There is evidence on record. I cross-examined the human resource manager of Mauritius, and I put it to her, my lord. You are saying that the contracts were renewed at the request of appellant. I put it to you, I told her, that is not true. You said yourself, you do the planning. You know how many pilots you need. Is it not you who asked him to write the letter? After 3 or 6 questions, my Lord will see on record, I can quote, she admitted that the contracts were in fact renewed at the instance of the employer of Air Mauritius. Whereas much is made in the submissions and the argument of respondent, the contracts were distinct, they were separate, etc., blah, blah, blah. It's not true. Any company is not going to wait for a pilot to decide if he wants to work or not. That is just not on. That is too simplistic. So you need assurance you will have pilots. And yet this thread of obfuscation, runs throughout this case, where the respondent is unable to come with the clear truth. Because at the end of the day, if you ask, why was the appellant dismissed? I'm afraid there is no reason. Save there was an economic crisis. And it is no coincidence, my Lord, that in the letter of dismissal itself,
108, is that, Mr. Beebe?
Yeah. Yes.
Yes, what about it?
So the letter of dismissal starts in the face of the economic crisis, growing in intensity. You will notice that there's no link between that worldwide economic crisis and Mauritius or Mauritius. All we are told, appellant is told, in the face of an economic crisis, expect losses incurred and expected with edging, exacerbated by drop of traffic. That's it. That's the reason. That's what is mentioned in the letter of dismissal. If you go now to the evidence of the human resource manager, which is to be found at page 50, Mrs. Akbar. First of all, very quickly at page 57.
Yes, very well.
57.
Yes.
My Lord, you will see an answer, yes, the company decide. After a bit of wrangling and pushing and on and off, I mentioned that, but at page 54,
yes.
Page 54, to the question, why was the employment of particular person, Mr. De La Haye, terminated? The answer is the operation of the decision to terminate De La Haye was based on the fact that we had a financial problem and we had to reduce costs. That's the nearest we get to a reason in this whole case, my Lord. We get no more than that.
And it goes on, doesn't it, at the top of 55?
Yeah. And
it looked like a leading question from Mr.
Yeah, very.
Haye, but he prefaces this by saying, as already accepted by the plaintiff. He was one of the highest paid pilots, yes, enjoys various allowances which the Mauritian pilots didn't, indeed, package substantial.
Well, my friend was very helpful to the witness.
Etc. Yes, very well, thank you, that's helpful. Anything else then, Mr. Beebe?
Well, yes, something most disturbing. I would beg your indulgence to
briefly, please.
Very briefly, I will
yes.
do something most disturbing. At the end of the judgment of the learned judges.
Yes. Two to 8.
Two to 7.
Yes.
Now we'll need to 2 to 7. there is note 364 at the beginning of the page. My lords, 227.
Yes, I got that.
At the beginning of the top of the page.
Top of the page, yes.
I will have to refer your lord to the translation in this document, which is found
Well,
at 914.
we can probably cope.
At 914.
We can probably cope with
Okay,
note 364.
Okay. Now, I'm going to, if I may, my lord, I will not take much of
Parties can freely, in their agreements, fix all the relative conditions, etc.
etc. And then you have ... my lord.
Yes.
Well, if we take the pain to read on after the ... here
Yes.
is what we find.
Where do we find it?
At 914.
914.
At
Very well.
913 you get the French version. At 914 you get the English version.
This is from Dallo, isn't it?
Exactly.
Right.
Dallo's Répertoire pratique.
Yeah. So it's a text. 364 ellipsis.
914. In fact, that's in the supplementary. No.
It's
Yes?
loose.
I'm afraid I don't have.
It may be loose.
It's in the bundle that's loosely tied. That begins Appeal Proceedings 2.
I'm sorry to be behind.
The bundle where the Act was.
Oh, right.
Oh, right.
Got it.
Let's
Thank
talk
you.
about it.
I think we're getting there, Mr. Beebe. You're very kind.
Got it.
Give us a moment.
Thank you.
We've all got it now. Thank you. Yes?
Now, their lordships in the Supreme Court ended with the word rupture, which in the English translation is termination. Now, if I may, my lord, I will continue in French first, since you explain you have no problem.
Yes, do.
913.
Qui doit être donné et laisse entier le droit de la partie qui aura à souffrir de cette rupture de demander des dommages-intérêts à son contractant si celui-ci a agi abusivement.
Yeah.
In English, it goes, these clauses, having in mind, in my view, clauses like clause 10A, that's no dispute about that in this case, that's what the judge has in mind, and leave the entire right of the party who will suffer from this termination to claim damages from his contracting party if the latter had acted abusively. So therefore, my lord, by not quoting the entire paragraph, we've got a very perverse understanding and applying part of a principle to a situation that demands a full application of the principle. I found it most disturbing that you can break a quote at this point because the next sentence gives the sense, the balance to the quote. There is a rupture. What arises of the party in case of rupture? That right is completely deleted. It's not, I consider that very disturbing, to put it mildly. Now, I don't want to abuse, I have said. All I will conclude by saying, my lord, in my conclusions on my statement of case, I list almost in bullet points, in very concise form.
Let's just turn it up to remind ourselves, please.
Can I just be clear that I've understood correctly the point you're making under reference to the passage?
Sorry?
Can I just be clear that I've understood correctly the point that you're making under reference to the quotation you just read out from Dalloz?
Yes.
If I'm following the argument, you're saying that the Supreme Court erred in thinking that because the termination was by means of exercising a contractual right to terminate, that was the end of the story, and Section 46 had no application. And if I'm following your argument, you say Section 46 actually reflects the French law in this way, that even if there is a contractual mechanism for termination by notice, and that is exercised, there is nevertheless a right to claim the equivalent of damages, a severance payment, under Section 46, if one of the conditions in subsection 5 is satisfied. So, for example, if the notice was served for reasons of racial discrimination, that would be a forbidden ground of termination, even though there was a contractual right to terminate. Is that the point?
That's the point. But that point is in fact reinforced by the statute, I would say, exigency of the statute, that such clauses should never be applied in cases of fixed duration.
Well, I wonder if that may not be going too far.
Well, that's my difficulty. That's what Section 37 provides for.
In the Mauritius Steamship Company case,
Yes.
there was also a passage from the French sources cited.
Yes, yes.
And I think if it might be as well just to take you to it in case.
Well, in fact, I discussed this point thoroughly in my.
I may have misunderstood it, but I think you took us. Was it at 552?
Sorry.
Yeah, the case was in.
Sorry.
The case begins at page 549, Mauritius Steam Navigation Code, and Roussetti. And they begin by, and you took us to page 551, the final sentence of the penultimate paragraph. What if a fixed-term contract is terminated by the employer before the predetermined date or event? And then, they answer, they first of all consider the position under French law. And on the following page, in the French, the paragraph number 279 says, from the moment that the termination to which one of the parties proceeds before the agreed term of a contract isn't justified by force majeure, faute grave, or son accord. It constitutes a violation of the agreement and gives results in an award of damages. Yeah. Now, well, doesn't that, so the agreement? So if effectively, if there's a legitimate reason for bringing the contract to an end, in terms of force majeure, fault on the part of the other contracting party, or the agreement of the other contracting party, then there's no right to damages.
Yes, my lord.
Yeah.
That is why, in fact, what the section you have called is exactly is along the same line as the note 340, provided you read. Here you have the whole of the note. In steam navigation, what is quoted is in fact reproducing that note.
Yeah.
But that note, we were only given half of it. But what you consider is a full version of the note.
Yeah.
Full principle.
So the agreement is, on your interpretation, agreement means agreement to the termination, not simply agreement to a procedure for termination. Is that?
Well, I would say to both.
Well, if it's simply agreement to a termination for, if it's merely agreement to a procedure, then the procedure could be used for to terminate a contract for reasons which you would say were illegitimate, such as racial discrimination.
Yeah, I see what your point is. I see.
So you're reading it as being agreement to the termination, rather than agreement to a procedure by which a termination could be effected.
Yes. That will make more sense.
Thank you very much.
Thank you, Lord Reid. I think you said, in conclusion, you wanted us to look at your written conclusions.
Yes.
And they are at 322, 323, and 324 and 5. We have read them very carefully, as you would expect of us. But what in particular did you want to say, winding up your submissions, Mr. Beebe?
Yeah. But first of all, I would like to refer your lordships to, I will not quote it because it's a very important judgment, but to the case of Gisda versus Barat, because in my view, if I may recall the case of Gisda versus Barat and the pronouncements of Lord Hoffman that is quoted, in my view, is very
We know the Gisda case quite well.
Yeah, I'm sure.
We
That's why I
find it
just
quoted to us in the Supreme Court pretty well every month. You want us to focus on the general points that Lord Kerr makes about statute in certain circumstances now, in modern times, overriding contractual principles. We follow that, and then, of course, Lord Kerr goes on to deal with the specific question of the date of notice of termination, which can be relevant under our statute. But we've got the general points he makes, and knowing
no, just the background. I said background.
They're unlikely to be wrong.
No, but my lord, as I come now to my conclusions.
Yes.
In particular, I want to point out the point 2. I don't want to go on the issue of effectivity, that's on record.
Yes.
Except that it must be established once and for all that in this case it was the employer that took the initiative to terminate the employment. The judges keep using the passive, the employment was terminated without identifying the agent. That is the point. Because, and that is what, everything goes wrong there. Because if there's nobody who terminated the employment, therefore the very first condition for severance allowance is out. So it seems to me, as a matter of fact, it's so obvious that this contract was terminated by the respondent. And the third point, too, is important, because it is argued by my friend, both in writing and in his written submissions, that severance allowance is excluded for employees under contracts of fixed duration. I argue and I demonstrate that the case of Plantation Workers Union versus the UN was wrongly decided because there's this pronouncement there that somebody under fixed duration can never get severance allowance. Mauritius Steam Navigation negates, so it says in some cases, like the present one, you can. That's one point. And, well, point 4 has been ruled out because I rule out
yes.
point 4. I won't mention it. So does point 5
yes.
and 6. Point 7 is important because it shows there is no sufficient evidence that justify that demonstrate the validity of the economic grounds.
Yes, you've made that
Yeah.
point. We understand the way you put
and
it.
point 8, again, is a matter. Point 8 is a matter of the issue. One aspect of discrimination, because it's not only discrimination there. It is above all unreasonable and unfair. It's just a matter. There are many dimensions to this issue, to how the selection of the pilots were made to be dismissed. There is an unfairness and an irrationality actually involved there. Why pilots only? Why foreign pilots? There's no explanation given except they are highly paid, etc. Number 9, I believe, is important for the attention of your Lord, the Labonchid case.
Yes.
Number 12 and 13 and 14 is very important, my Lord. Because one aspect of being unreasonable is when you actually, in law, and there's various authorities quoted there, the bundle, particularly the case of Chateau de Garches versus Dame Lafleur, where a hotel recruited a new maid after having dismissed another maid, and that invoked economic grounds for dismissing the first maid. The principle involved is that if you are making people redundant, you are not to recruit. And my Lord, even in the ERA, there's a section of the ERA where it is specifically said, if there is, I will give you the section in 1 minute, if there is any vacancy in an enterprise, priority must be given for recruiting from outside to part-time workers or workers on fixed duration contracts. I will give you all the section 10.1.
We'll look at that for ourselves. So, we've come down to the bottom of your 14 points. You've timed it beautifully. We gave you 2 hours for your submissions, and apart from a couple of minutes, you've used those 2 hours, and you've used them helpfully. We're going to retire now to see what we should do in terms of this hearing from now on. Thank you.
Thank you, my Lord.
Ms. Ardisman, I should have asked you whether you wish to follow Mr. Beebe.
I think everything that was necessary has been said.
Thank you very much indeed. Mr. ETA, we would like submissions from you of, and I know that we will receive them, of a focused character. We would like, in particular, submissions from you on whether there was continuous employment in this case, and on whether there was a unilateral termination of the contract by your client.
It is our submission that the definition of continuous employment, as interpreted by the appellant, is an absurd one. It is absurd in the wide sense of the term, as described by Bennion on Statutory Interpretation, 5th edition, page 969, to which reference has been made in my statement of case, and I would underline especially the words illogical and impractical. I say it is illogical because there are factors in the agreement between the parties which show that the parties did not intend a continuous employment. First of all, there are three factors, in fact. First one is payment of a gratuity at the end of the 4-year period. At the end of each 4-year contract, there is a payment representing 1 full year's salary, because it is 25% of the 4 years period. Makes 1 year's salary. Now, why is it important? Because we know that at the end of the 4-year period, the appellant, or just any worker under that kind of contract, would not be eligible for severance allowance. And it is therefore provided that he will be paid an end of contract gratuity representing 25% of his full salary over the 4-year period. This is a strong indication that the parties do not intend to be continuously bound to each other. The second factor...
Well, can I just ask you about that? The gratuity is payable automatically, isn't it?
It is payable at the end of the 4-year period.
A severance allowance isn't payable automatically.
No. It depends upon, as Lord Hughes stated earlier, upon the conditions prescribed in section 46(5), A to D, and then there was E, which was added, and which has been overlooked up to now, in July 2009. So we have, in fact, 5 paragraphs today which speak of unjustified dismissal and the reasons for them.
Sure.
But, I mean, I understand the submission, Mr. Itier, that the parties did not mean to be bound to each other continuously, in the sense that at the end of each 4-year term, either could say, enough's enough, I'm off home, or whatever. But is that the test of continuous employment, or is the test, according to the statute, simply that there have been successive fixed terms without the relevant gap?
This is what the law says.
Does seem to, doesn't it?
The law seems to say that clearly. But
When you said it's absurd,
it's absurd.
you're saying Section 2 of the Act is absurd.
Absolutely.
Very well.
For the reason which I'm giving now.
Simply because the parties didn't mean to be bound to each other beyond the end of 4 years. But why shouldn't the Act say, looking back, if you've had a whole series of successive fixed term agreements, they could be 4 years like this, but they could be a month at a time, or even a week at a time. If you've had a whole series of successive fixed term contracts, we, the Act, say, for the purposes of severance pay, you ought to be treated as if it's been a single contract.
Yes, but we have also we have also Article 1134 of our Civil Code, which stipulates that the agreement entered into by parties have force of law between them.
Well, yes, that simply means contracts are binding.
Are binding, yes. And but my point is that it would need clearer language than the one which you find in Section 2 to override that fundamental principle which has been enshrined so long ago by way of Article 1134.
Well, I think the definition of continuous employment goes back a long way, doesn't it, Mr. Itier? Goes back to the Labour Act, perhaps even before.
Goes back to the Labour Act, absolutely.
Yes.
Since 1975.
Very well.
Mr. Itier, your submission proceeds...
Earlier than that.
Your submission proceeds prospectively, what the parties intended when they entered into these various agreements. Section 46 is looking at it from a different perspective, isn't it? It's looking at it after the conclusion of the relationship, looking back to see what has actually happened.
That's for payment of severance allowance.
Yes.
Yes.
Yes. The reference to continuous employment there requires continuous employment to be assessed in the light of what has actually happened.
What we are saying is that the 4-year contracts are distinct, autonomous, and do not constitute continuous employment, except for the 4 years period.
Yes.
I mean, it's been working for 4 years, so if it were, he's not entitled to any severance allowance if it is a contract of fixed duration, by reason of Section 36, subsection 1.
Because it simply expired.
Yes?
Yes. So this is at page 806. Subsection 1.
Yes.
It says, subject to any express provision in an agreement. So far as relevant, it says, subject to any express provision in an agreement. Every agreement shall terminate on the last day of the period agreed upon.
Mm-hmm.
So this is the end of the story for both parties at the end of the 4-year period. And there's no payment of severance allowance which is due, because that is a fixed-term contract.
Section 46 wouldn't arise because there would be no termination by the employer in that situation.
No, that's it. It is a mutual agreement.
Yeah.
It is a mutual agreement. That's it.
Okay, well,
So
that's what you say about continuous employment. If the interpretation section is not absurd, Mr. ETA, then on the facts here, there was continuous employment. You accept that?
Yes.
Very well. Well, then, what about the termination? Was this termination on these facts consensual or unilateral by your client?
It was consensual. It was consensual because both parties agreed by virtue of clause 10A2 of the contract that either party may terminate the agreement by giving 6 months' notice to the other during the currency of the contract. That is the clause in the contract signed and agreed by the parties, and it appears in each contract which have been signed by the parties. Now, it is in furtherance of this clause 10A2 that the termination occurred. So it is an application made in pursuance of a consensual and mutual agreement between the parties. That is why I submit it could not be a one-sided termination, because a one-sided termination occurs without any prior agreement by the parties.
Well, let's look at your letter of the 27th of February, if you've got that to hand, Mr. ETA. I think it's at 108 in the basic bundle. Third paragraph, we regret to inform you of management's decision to terminate your contract.
Right.
Are you really saying that this was a consensual decision to terminate?
But if we read on, my lord,
Yes, of course.
see, pursuant to clause 10A2 of your contract, dated
Yes.
16th of June 2006, this letter serves as a 6-month notice for the termination of your contract. And clause 10A2 clearly specifies that whether it be the employer or the worker, either of them can give notice of termination. What applies for one should apply to the other. As I said,
Either of them can. Who did?
the employer,
Yeah.
the employer did, but the worker could have done so as well. If he had got a better package deal elsewhere, he could have availed himself of clause 10A2 and send a letter in virtue and in pursuance of this mutual agreement between the parties.
That wouldn't have been unilateral either, you say?
That would not be unilateral.
Or indeed a termination by him?
Sorry, Honor.
Would it be a termination by him? Supposing after 2
Yes.
years, 2 years he thought he'd much rather go home, and despite the attractions of the present job, job and gave 6 months' notice, would that be a termination by him?
Yes.
Then why isn't what you've done a termination by you?
It is termination. It is termination in pursuance of a mutual agreement, because both parties intended it to be so.
You see, 46 only requires that the employer terminates the agreement, doesn't it?
46.
46.1.
Lawyer, yes, that's correct.
So your submission has some pretty far-reaching consequences for Section 38. For example, Section 38(1)(a) prevents an employer from terminating an agreement for example, pregnancy. If Air Mauritius were to dismiss its pilots, its female pilots, whenever they became pregnant, on your argument, the women would have no protection under Section 38 because the employer had not terminated their contract. It was terminated by mutual agreement. I think you have to face up to that, don't you?
Well, that is a distinct matter because it would involve probably some kind of abusive behavior on the part of the employer. But we are not in this case here.
Well, Section 46(5) provides for compensation in the event of abusive behaviour of that kind.
Yes.
The case I just gave you is in Section 46, it's 5B. The termination of the agreement was in contravention of Section 38(1).
That's correct.
But on your argument, Section 46(5) wouldn't apply to the case of the pregnant pilot whose agreement was terminated by notice because of her having agreed to a contract under which her employment could be terminated by notice.
Because it would be justified in accordance with subparagraph E of the Act, because it is made in pursuance of a mutual agreement.
Yeah.
So
Well, it's a simple point, right or wrong, Mr. Etier. Is there anything more you want to say on that point?
not really, my lord.
Another thing, perhaps you can help us, that we were worrying about a bit when we looked at Section 46, the payment of severance allowance. And for this purpose, assume, perhaps not this case, perhaps it is this case, that the worker has been in continuous employment. First, assume, perhaps it's this case, perhaps it isn't this case, that the employer has terminated the agreement. Then severance allowance is payable in accordance with subsection 5. And we were wondering a bit about a termination by the employer which actually didn't fall within any of the reasons A, B, C, and D. Perhaps a thoroughly unreasonable, unexplained termination. But it wasn't due to the reasons under Section 36(3) and 4, didn't fall within A, didn't fall within B, nothing to do with misconduct, C, nothing to do with the economy, D. And we were wondering whether in those circumstances severance allowance would be payable, and why it wouldn't be payable. Now, can you help us on that?
It should not, there is also E, which must
That perhaps is the answer to it.
This is the answer. This is why they added E, I believe. It is more general.
Is the effect of E that the employer always has to justify a termination?
He has to justify it either by reason of any failure on his part by reason of 5, A, B, C, D,
Yep.
and E.
Yeah.
He
Well,
has to
I know you
justify
say it's justified by the terms of the contract.
Right, or by, exactly.
Yes.
This is what I was going to say.
Yeah.
Or by the terms of the contract, because terms of the contract would make it fall under E.
I follow.
It would be justified then. As I say, E was added in July 2009, and I have given you the page at 816, 800 and,
We've got
That's
it
it.
731.
no, it's 817, at page 817.
817.
Yes, Lordship will see that a further subparagraph E was added, section 46(5).
Yes.
This was added by way of the Finance, this is rather particular, the Finance Miscellaneous Provisions Act 2009, which is reproduced at page 816. And
Yes.
And so at page 817, we see at J, in section 46, J2, in section 46, subsection 5,
Yes.
by adding after paragraph D, the following new paragraph, that is, the termination of agreement with the worker was unjustified. So what my submission is that if the parties are abiding by their contract, then the termination is justified, and the respondent has done nothing unlawful. This is my submission.
Yes. Well, Mr. Etier, unless there's anything more you want to say, that's very helpful. We did allow, rightly or wrongly, we did allow Mr. Beebe to address us for about 20 minutes on the economic side. Now, you were sitting there very patiently, perhaps getting rather angry. Do you want to add anything very, very briefly on that?
There is unchallenged and abundant evidence that at the material time, that is 2008 and beginning of 2009, the respondent was in dire financial straits. At the end of 2008, the losses amounted to 18.3 million euros, and by March 2009, they amounted to 83 million euros, which in Mauritian rupees is not huge, but enormous.
And that's a loss for the year ended March 09. Is that what you're saying?
That's correct. Yes, this is the financial year is from the 1st of April 2008
Very well.
to the 31st of March 2009. And this is the situation at the end of March 2009. And the company needed the guarantee of the government to obtain its cash flow. And it was so difficult, the situation was so difficult, that any further guarantee by the government involved the taking of drastic remedial measures. And that is why, before a few pilots were told to leave, other measures had already been taken. And I have already indicated in my statement of case the nature of these remedies. I'll just highlight them.
If you can refer us to where the evidence about that was given,
Yes.
we'll read it in our own time.
So, first of all, the respondent secured a guarantee from the government of Mauritius to reassure the hedge creditors. This is at document R, that was in December 2008, and at page 167 of the record.
Yes.
And then secondly, the employees were encouraged to take special leave without pay of up to 2 years and to engage in part-time work entailing a reduction in salary and overtime payments. And this is stated in document L, dated 10th of February 2009, at page 150 of the record.
Thank you.
Then several pilots were granted leave without pay, and recruitment was frozen, but then it was not enough. And the respondent had to take further measures, which included the termination of employment of several expatriate pilots. And as a result of these measures, then the losses decreased. And that was as a result of those measures. Without those measures, the results would have remained the same. And of course, the company would have probably faced insolvency.
Well, that's helpful, Mr. Etier, to remind us of that. Unless there's anything more you want to say on any aspect, I think that's about it.
That's about it, yes. Yes.
Well, we're grateful to you. But my Lord
Yes.
Lloyd Jones has a point.
Forgive me, with my Lord's permission. Mr. Etier, could I take you back for a moment to section 46 in its unamended form, that is prior to July 2009, which is the version that we're concerned with?
No, we're concerned with after July.
Are we concerned with?
Because the termination of
Right.
employment took
So
place in September.
it's subject to E.
Yes.
In those circumstances, is it your incorporating E?
Yes.
Is it your case that section 46 has no application at all in circumstances where a contract is terminated pursuant to a clause such as clause 10? Or is it your case that section 46 applies, but the termination is justified because of the introduction of E?
This is the second part of your question.
The second.
Yes.
Thank you. Very grateful.
Any questions? Mr. Etier, thank you very much indeed.
Right.
Just hold on, Mr. Beebe, a moment. I think we need to call on Mr. Beebe to respond on continuous or on unilateral, do we?
No, I don't think we do.
Sure. Do we need to call on Mr. Beebe for submissions on continuous employment and unilateral?
As far as I'm concerned.
David? Mr. Beebe, there's not much for you to reply on because we're not calling on you to reply to the arguments we've just heard from Mr. Etier about continuous employment and about whether this dismissal was consensual or unilateral. He's made some bold points, and we're not asking you to respond. And you may be able to infer why we're not asking you to respond. He's mentioned the economic aspects very briefly, because you weren't, in fact, entitled to bring it up at all. But was there anything arising out of what he said about, well, before we dismissed before there was a consensual termination of the employments of the expatriate pilots, we did take a number of measures to see whether we could stem these vast losses. Was there anything you wanted to say about that?
Very briefly, my Lord.
Yes.
I'm very conscious of our benefited from ship indulgence in the circumstances, except that, yes, two things take me quite baffled, very impressed by the boldness of the points, as you say, regarding Section 2, but I am taken aback by the equally bold assertion that the economic situation of Mauritius kind of improved dramatically after the termination. Unfortunately, there was no reference to any evidence on record about this practically magical recovering by sacking appellant and that. There's nothing on record in the evidence of anybody on this issue. It is sheer, it's a declaration. It's just like it is in speaking.
We will, of course, reread the evidence.
Yeah, but there was no reference to it.
I thought I had read evidence that in 2009 the losses were far less than they'd been in December 2009,
Yes.
far less than they'd been in March 2009.
We made that point, yes.
Yes.
But the linkage between any diminution of losses
Yes, I
and linking it to the sucking,
I see.
there's no accountant
That's the point.
made that point.
Yes.
Just like I called it, and that's my last sentence, I think it is again a speculation to suggest that gratuity is some form of severance allowance, that gratuity has to do with, as it in the written submissions of appellant, gratuity is equal to, because there won't be pension rights, that's why gratuity is paid. This is stated without any explanation from the HR manager, from the accountant. Just, if I may say so, from the bar is being interpreted, gratuity is being interpreted as meaning that. So, and one more thing, I am a bit at a loss, my lord, regarding the calculation. If the event, in the event of the ownership and ownership will determine that the dismissal was justified in conditions where severance allowance is payable, there are problems regarding the calculation of such the issue
Certainly,
of gratuity.
there would be an issue about credit for gratuities. For one thing.
Gratuities, question of interest, question
We
of
understand that.
remuneration.
We wouldn't be wrestling with that.
Yeah.
Well, Mr. Beebe, unless there's anything more, I think that's it. And it remains for the board to thank you and Miss Arbisman, and you had two others assisting you, and Mr. Etier and those assisting him. Thank you all very much indeed, and we will take time to consider the judgment.